Hey guys, thanks for making it here today. So, we'll give it a couple of minutes while people just slowly get their way in. But just kind of wanted to touch base with why I'm talking about LLCs or why it's kind of a bigger issue to pay attention. And we've set up literally probably 1,000 a year because every deal that we're doing where you've got multiple different uh, entity structures and business purposes where we may do one deal and it can have anywhere from 2 to 10 plus different entities attached. And I say entities in general because, yeah, sometimes we use limited partnerships, other times we'll use corporations, but for the vast majority, we're just using LLCs. So, and I know there's a lot of law firms out there and attorneys that they have their entire business made out of creating LLCs. And you know what? For us, it is a necessary evil. Yeah, we have to set them up. It goes as part of the overall structure. You use it for business. We charge something to set them up, but I got to be honest, we're just as happy if you set them up yourself. So today we're going to go through a little of that of how to set up an LLC where you can actually do it yourself, how they're used, and frankly, at what times do you need to hire an attorney? And other times you're perfectly fine to just do it yourself. And to start with, this is a lawyerly talk. So just want to make sure everybody understands that the purpose of being here today is purely educational. If you need advice, reach out to an attorney, reach out to your CPA, your financial advisor, reach out to anyone that is there to actually help and knows and understands what is going on. So, as I touched on today, we're going to be talking about LLCs and how to get all set up with it so that, at the end of the day, you understand the uses of the LLCs, why it's important to leverage them, and really the flexibility of it all. So, today we're going to be talking about the literal process one, two, three, four of setting up your own LLC. If you're doing it as a partnership, the types of considerations that you need to have taken to mind. All businesses cost money to get off the ground, so we'll talk a little bit about that. When attorneys are actually necessary to be part of the process, and how to leverage your LLC for asset protection purposes. Really, I'm here to give you the download on how to make life as easy as humanly possible and to be able to save you money so that you don't actually have to hire attorneys every step of the way. But let's start out with the most basic question. So, you want to start a business. Now, there's a couple of ways to start a business that isn't very protected. Now, I've brought up the types of entities that we can use, the limited partnerships, the corporations, and the LLCs. All of those are known as limited liability vehicles. What limited liability means is that you can get, well, if the company gets sued, those creditors cannot reach your personal assets. There are a couple of types of business entities that aren't really business entities and they're not limited liability. That is the sole proprietorship. If you set up your own business, you're not doing it through any sort of entity. You are technically a sole proprietor. Secondarily, we've got general partnerships. There's a difference between a limited partnership and a general partnership. But if you don't file a limited liability entity, you are a general partnership. Now, for both of those, if there's ever a lawsuit of the business, you can be held personally liable for anything that happens with the lawsuit. And I bring that up because it is a horrible situation that, especially when it comes to a general partnership. A partnership where you don't file with the state of any limited liability enterprise. People talk about joint ventures all the time. And I just want to be clear that a joint venture defaults to a general partnership that everybody has unlimited liability. I don't care if you own 1% of that partnership, you're 100% responsible for any liabilities, risks, or issues that happen through the partnership. So that's where it gets to be really important to know and understand the options for limited liability vehicles. And for today, we're going to be talking very specifically about creating an LLC. As I had mentioned, there are other limited liability vehicles, but the fact of the matter is the LLCs are the most used and most versatile of a type of entity that you ever end up using. And just so that you understand, well, what happened here? There we go. Once you're setting up an LLC, the process is you file with the Secretary of State of whatever state you're setting up the entity under. Now, if you're buying a operating business that has a location, or you're buying real estate that, of course, it has a location, I am a huge fan of actually keeping life as simple as possible. And if you're already subject to the laws of the state that the business is located or the real estate is located, I'm a huge fan of just forming the LLC in that state. You're already subject to the laws. Yes, you can form in a different state like Delaware, Nevada, Wyoming, and we're going to walk through the process for each one of those states, what you got to do to set up your own LLC. But again, that's only if there's really not a business location. So when we talk about like uh, a syndication to acquire a commercial building, there's one entity that will own the real estate. We'll generally end up flipping that in whatever state the real estate is located in, but oftentimes there's a management LLC that provides the ongoing management to that company. The reason why we set it up as a separate LLC entity is actually provide an additional layer of limited liability protection. There's always some risks in business. There's always some risks in bringing in investors. So just like I would encourage anybody to own your share of a business through a limited liability vehicle, an LLC in general, the same holds true if you're managing an investment. You still should have all of your operations and what you do actually through the LLC itself as well. Now, we're going to talk very specifically about Delaware, Wyoming, and Nevada. Reason being, these are the most common states to form entities in. And we're just going to go through state by state and talk about it a little bit more general. And we'll kick this off with let's talk about Delaware. And just so that you understand, we do have a download where you can get all of this information. If you don't mind just going to this QR code, click on it. There's going to be a page that you can actually download all of the links that we're going to be talking about, as well as we're going to have a templated operating agreement. So, like I said, we're literally setting you up so that you're not going to need to hire an attorney to set up your LLC. Now, there are times that attorneys are necessary evils, but until that point, don't worry about it. You can set them up yourself, but please go to this QR code. It'll take you right to these pages that we're going to be talking about. And we will start with There we go. And we are going to start with talking about Delaware. Delaware, it's one of the biggest states to set up any sort of entity. The reason why is multifold. To begin with, Delaware has great protective laws for lenders. It's pretty often in the past that we were required by a lender to set up a Delaware entity so that the lender is protected by their law. Another thing is Delaware has its own business courts. Some states have this. Delaware is very business friendly, so there's good ways to set up your LLC there. And then the final reason why Delaware is a great state to form in is confidentiality. It is such a pain to get information very specifically about the LLCs or the any information about a business through Delaware, that it's a great state just to provide that protection, the exact opposite of transparency. And to start with, we'll go to the delaware.gov. They have a page that's literally the step-by-step process for forming a new entity. Choosing the type of business entity. Every state in America, everywhere, requires you to have a registered agent. That's talked about right here. With a registered agent, what it means is there is somebody, and that somebody may be a person, it may be another company, but somebody within the state that the company is formed serves as that registered agent, which means if there is ever a lawsuit that gets filed or a public notice for taxes coming from the state, or like I said, any type of lawsuits, rather than it getting served on to you directly, any of the paperwork is served on the registered agent, and then the registered agent's responsibility is to send it to you as the actual company holding it. And then while we are going through the actual process of setting up a company, we're gonna look at this, but some states will call it a certificate of formation. A certificate of formation, that is what creates the LLC. Other states call it articles of organization. Actually is the exact same thing. Corporations, there may be articles of incorporation or certificate of incorporation. It's a little bit of a tweak in the wording, but at the end of the day, it always means the exact same thing. So in Delaware, we have a certificate of formation that is actually used. That is what we will file. Now, in the state of Delaware, there are 2 documents that will be filed with the state. One of them is we call it the cover letter, which basically just runs through I need to order this LLC. How are they gonna send the information back to you? And then it also does some additional costs for if you can't do regular processing. I will say with the state of Delaware, even with normal processing, we tend to get an entity back within about a week, give or take. But so then the 2 documents that's this cover form, giving the basic information about needing to order the LLC, and then secondarily, we have the actual certificate of formation. And I want to really point out how simple this document is for the state of Delaware. To start with, first, the LLC's name. Second, the registered agent and who they're gonna be. Third, whether or not the LLC is getting, uh, deferred in terms of the creation or if it's immediate with the filing, and just generally other stuff. Now with the state of Delaware, you can't find out, and if you notice with this, there's not a line that says, "Who are the managers?" Who are the owners? What's the address of the company itself? None of this information is being requested when you're creating a Delaware LLC. And even once you do go to the website, if anybody's trying to search out what do you own, you can't search your name directly. They have to know the identity of the LLC, and then they can pay $25 to search every LLC to figure out which one you actually have management controls over. So Delaware, I love using the state laws to set up entities, use them a lot for the confidentiality of it. Costs about $250 per year in the state. Franchise tax, the filing fees with the state. After the first year, you do have to let them know who manages and controls the LLC as well as the address. But to just get it set up, you're not providing any of that information, and at any time, it's a complete pain to figure out who actually owns or controls a Delaware LLC. So just to high level recap, to form your Delaware LLC, you need to fill out the order form. You're sending the forms and the filing to the Division of Corporations in Delaware. And only second document that you need is this Delaware Limited Liability Company certificate of formation. That's it. It literally is that easy. We're going to go through a few other states, and then we're going to talk a little bit about the other documentation that comes together when buying or when setting up a company. But another state, Wyoming. We set up companies in Wyoming more often nowadays than we actually set up in Delaware. The primary reasons behind that still have great secrecy laws, have fantastic asset protection laws. It's also quite a bit cheaper to file for the LLC as well as maintain the LLC in Wyoming compared to Delaware or frankly a lot of the other states that are out there. So here's the step-by-step instructions with this web page of what it takes to actually form a Wyoming LLC. Again, let me mention, go to that QR code. We're also going to drop it in chat so that you can just get the links to all of these pages. You don't have to scribble them down, write them down. You're not really noticing much. But let's talk about the simplicity of the actual filing documents. Where I was saying that the articles of organization, same thing as the certificate of formation. Wyoming, they just simply call them articles of organization for no good reason. There's still a cover page required for the filing. Well, it's just the first page that has the setup instructions with a filing fee of only $100 right before you're actually filing the articles of organization. Now, with this, you're providing a little bit more information, but it still covers a lot of the basics, like what's going to be the name of the company, what's the address of the registered agent, a mailing address for the LLC other than the registered agents. And then, of course, you always have the organizer's information, and a little bit different than in Delaware. In Wyoming, there's a consent to the appointment. So this document actually has to be filled out by whoever is going to be serving as a registered agent for your LLC. If you're using a corporate registered agent, they have to fill this out and sign off on it before you're actually sending in these certificates or the articles of organization. So you have to figure out this registered agent before you actually get moving forward. And you can't say, well, I'm going to be my own registered agent unless you're actually living in Wyoming. So we use a national registered agent incorporated as the corporate registered agency that we tend to go with at crowdfunding lawyers. The only reason why we do is they provide this service in all 50 states. There are some that are cheaper. There are some that are more expensive. The cheaper ones will tend to only do, like, Wyoming, and, if you're setting up a whole bunch of them in Wyoming, where the National Registered Agency, Inc. may be charging $125 a year, others guys may only charge $50 to $75, but then you gotta deal with the registered agent in the different states. So, we do love Wyoming. Wyoming came from, well, really the granddaddy of all asset protection, which is Nevada. Nevada, going way back, has had phenomenal asset protection laws. Their business laws, they also have a business code similar to Delaware. They used to be unbelievably cheap, the cheapest in the country, to actually set up your LLCs. It's definitely changed over the years. They've increased their pricing. They've required state business licenses. They've gone through a number of different steps to increase the costs. We're filing less in Nevada now than we ever had in the past, but because there's such a track record in Nevada, I still have God knows how many entities in Nevada. It does make sense, and we do file there on a regular basis. Very similar to both Wyoming as well as Delaware, we're giving you a step-by-step instruction, a literal roadmap of what you need to do in order to set up your LLC. Unlike Delaware and Wyoming, Nevada has set up a business portal where you can file all of your documentation online, you can pay for it online. They are streamlining the process where instead of days, if you file for your LLC online, you can get it back within minutes. So in terms of expediency, and if you've got a deal that's closing tomorrow and you haven't taken the time to set anything up to close into or to own the property or to own the business, Nevada is a great way to move quickly at a moment's notice to be all set up in order to get your entity going. So where I was saying that you can do all of this online, just so that you understand, you can still do the paper filing. We used to have to do paper filings for one reason or another, and when that was taking place, oh my god, it would take weeks and weeks to get documentation back from, the Nevada Secretary of State. Thank the Lord they went to their online processing because ultimately it streamlined everything substantially more. Now, when it comes to the Nevada, again, now we're talking about articles of organization again. They're asking for a lot of the exact same information. Name being registered in Nevada. Same thing as the LLC name. This is actually there is quite a bit more information that's asked in Nevada, such as the jurisdictional formation. If you set up a company in Delaware to buy a property in Texas or in California or any other state for that matter, where I was saying you are still subject to the laws of the state that the property or the business is located. If you set up in Delaware, you have to file as a foreign entity in whatever state the assets are located at. This question in the Nevada LLC form, the jurisdiction of formation or the foreign entity name, they're asking that because, hey, if you set up your company someplace else, but it owns real estate in Nevada, where was that company set up? Kind of a really interesting quirk. The states can charge just as much, if not more, to set up a foreign entity compared to setting up a brand new entity. To give you one example, and I've dealt with this quite a few times, Texas, where I'm located. To set up a new LLC, the state filing fee is about $300. Now, the state filing fee to file a foreign entity in the great state of Texas is $750, more than twice the cost. than just setting up an LLC literally from scratch. Couldn't tell you why, doesn't really matter, but a lot of states do tend to charge more compared to just setting up the entity to begin with. But with this same questionnaire, it is still asking all the same information such as who is the registered agent? Who actually does the management? This form, and it's not available online with any of the states that we're talking about, does not include a list of owners. It does include a list of managers. And all of the states, whether or not it's on the original application or with annual updates, do require information about who manages the company. And if you haven't heard, now the US government just passed an act that they want information on not only who manages, but material owners of every LLC in America. So that's something that is coming up. They're required to be filed by the end of this year for the prior set up LLCs, and we're going to have in place kind of just as part of our process. We set up the LLC, we report to the federal government, and I hate to say that there is no good way around that. Um, so just a whole nother thing to be used to. So as I was stating, if you want to go to those pages, if you want that step by step to set up your own LLC, this QR, just put in your information. You're going to get all that information and then more, because we're going to start talking about, well, it's less complicated, but partnership problems. Now, when it comes to dealing with partners in any sort of limited liability company, it's generally done through what's called an operating agreement. Some states call it an agreement. At the end of the day, it's all the exact same thing. But the operating agreement is the legal document for how the LLC needs to be managed. And I'm going to talk a little bit more about the partnership aspect of it because that's where having the operating agreement is without a doubt. You have to. If you're setting up an LLC just for yourself that you're going to own and you're going to manage, it is just as important to have an operating agreement in place so that a court doesn't at some point look at an action, liability, or an issue and say, okay, well, you didn't pay attention to the corporate formalities of maintaining your LLC. So we're going to do, they call it piercing the corporate veil, reach through that LLC to hold you individually responsible. Having an operating agreement in place, even if you are the only owner, the only manager of that LLC is utterly important. Again, go to this QR code, go to the page, and what I'm doing is providing to you a template, a no-cost template to actually be able to fill out your own operating agreement. At the top of this document, it is the variables. They're in brackets for just fill out, search and replace this information within the template. And like I said, for you to have your own LLC, that is, you own 100% of it, you're going to manage it. The documentation that I provided in that landing page is literally everything that you're going to need to set it up. But when we're talking about partnerships, there's quite a bit more larger issues to take into account. To start with, one of the best parts of it is the flexibility of an LLC. In the example that I'm showing you, you can have multiple classes of owners along with a manager, where the manager can have ownership, doesn't have to have ownership. It can be set up with different classes, with different types of owners that have different ownership rights, voting rights, profit rights, and they're all underneath one LLC, and this gets defined through the operating agreement. That's where the flexibility really comes into play. One of the reasons why we use LLCs all the time with investment setups. We'll often have the manager having 0 ownership of the LLC, but still receives the management fees. If there's investors, maybe the investors are Class A, and they get whatever their profit share is based on whatever the terms of the investment. And then we'll have a second Class B that goes to the sponsors or to the managers, where the ownership of Class B is more passive ownership, so it doesn't have the same risk factors as the active management in terms of operations. So when we're talking about, well, we have the manager over here, we have different classes of ownerships, we have different ways that the profits are being split. All of that is there to be well defined within the operating agreement itself. And something that really want to be able to focus on, which is the voting rights, because there's a couple different ways to do vote. And I wanted to give you kind of the high level of, in this situation, here's how to do voting. In that situation, here's how not. And to start with, if you're just setting up an LLC for yourself that you're going to manage, you don't even need to worry about voting rights because it's just looking for your own approval for any type of business transaction. But it gets to be way more important having voting rights if you're bringing on partners, whether they're investors, whether they're active management participants, whether they're JV, joint venture partners, doesn't really matter. The voting rights is when everybody has to come together to actually agree, or at least to some extent agree, on more major transactions. Most classically, and if you look at the laws in most states, as long as you have at least a majority of ownership, 50% plus of ownership to effectuate, to cause whatever is getting voted on to actually take place. If it's between you and one other person, you're doing a small joint venture, you're not bringing in investors, it really is a true partnership between you and 1 or 2 other people. Voting should be easy. Pick up the phone, call Bob. "Hey, Bob, this is what I wanna do. Do you approve?" "Great." I like having a lot of voting requirements for the smaller partnerships, mainly because it keeps the partners on the same page. They know what to deal with, they know what to talk about, they can easily get things approved. However, if we're talking about a fund or a larger investment or a syndication that there are 10, 20, 50, 100 different investors, I like to really minimize the number of things that are voted on. And this isn't to try to take away power or any rights from any of the investors, but it is really based on the administrative simplicity of not having to contact the 20 people, 30 people, and get their vote on record. That can be just an administrative pain. So in those cases, really the types of voting that expect to see is if you're amending the operating agreement. If you're changing the terms of the investment before or after the investors have contributed their funds, you better give them a right to participate and to know. Any other major transactions that are outside of the business, if you bought a piece of real estate, yeah, there may be a right. sell the real estate or to refinance the real estate without the investor signing off on it. But if there's a decision to buy some other real estate, to make a loan to some other company, to do anything else, that tends to be outside the scope of whatever the business plan is, and there should be some voting rights to keep the investors, the members involved. So these are some of the types of voting that we have where it's either heavy on the voting for small partnerships, very on the voting for larger investor-based LLCs. Again, not trying to take anything away from any investor or member. LLCs have members, corporations have shareholders. It's all about the same. But it is about administratively, what is the bigger pain or not? One last thing that I do wanna bring up, especially if you're doing a small limited liability company, one where you're just having 1 or 2 other partners, is you and your partner really need to be on that same page as well. A lot of it is dealt with through the operating agreements. Very often, we'll put together what's called a buy-sell agreement. And if this resonates, the types of issues, feel free to just reach out, we're happy to help. But a buy-sell agreement means that if your other partner has certain circumstances, well, you have the right to buy them out. And those circumstances are often you're getting divorced. Well, you don't want an angry spouse in the business. So there may be a right to buy whatever share of the business that the ex-spouse may have fought to receive. Or if your partner passes away and you don't want that ownership of the company to go through probate, to end up with somebody, some beneficiaries that you don't even have any clue of who they are, the buy-sell agreement says, "Okay, this event has occurred. Now I have the right to buy the remaining business out." And oftentimes, it's funded by life insurance. So as an example, if you and I are in an LLC, we're in business together, we do a buy-sell agreement that if anything ever happens to me, you have a right to buy the remainder of the company. And you know what we're gonna do? We're gonna get life insurance. I'm gonna buy life insurance on your life, you're gonna buy life insurance on my life, and if something ever happens to me, you're gonna use the insurance proceeds to buy the remainder of the company. It's important to know how that is supposed to take place. There's some insurance benefits to you personally buying the insurance, then the insurance payoff comes to you tax-free, versus having the company buying the policies on one another, and actually the insurance proceeds are not tax-free. It's a weird quirk of the tax language that you have to, as an individual, own an insurance policy versus a company owning an insurance policy. But that's with the buy sell. Something happens to me, yeah, maybe it's gonna be a couple $1,000,000 payoff, but don't worry about it. We're getting life insurance in place, funds for you to buy the remainder of the business. And so that's how we leverage the buy sell agreements to make sure that you maintain ownership of the LLC after any divorce, death, if I become, incapacitated. All of these are different ways in order to protect your interest in your business. Now, I'm gonna dive in just a little bit and talk about capital. Now, I'm the principal over at Crowdfund Lawyers. A big part of our practice and focus is on raising capital for and from investors. But I wanna just touch on a few of the other areas that raising capital from investors is not the only game in town. If you are working with private lenders, we see this all the time in real estate, fix and flips, If you are starting a business, maybe you're getting a convertible promissory note where you're borrowing funds from somebody, but giving them right to convert in. Private lenders are not investors in the sense of a securities offering. So long as this really important component comes about, there is only one lender. Just to explain what a securities investment, when do these rules apply? Well, when you're pooling together money from multiple passive investors that they're looking for profits. If you go out and find multiple lenders that are gonna give you a whole bunch of loans to fund your business, you're doing a securities offering. There's a ton of rules around that. Just gotta make sure that you're doing it right. Reach out to competent attorneys that actually know what they're doing. Reach out to me. But as long as you only have that one private lender, it's not a securities transaction. You're in the clear, no problem. The second option is bank financing. With real estate, used to bank financing all the time. When it comes to capitalizing a business for acquisition, to acquire a business or just to start it up, bank financing is traditionally a much more difficult type of financing to receive. You have to have a net worth, a balance sheet sufficient to cover any of the loans. It is decided on a case-by-case basis by commercial banks with the backup and the alternative of working with the SBA, the Small Business Administration, which is part of the government. And they will give you a little bit easier terms to get their loan, but there's a lot of strings. To start with, you may have the lowest interest rate compared to a commercial bank. But in terms of going through the financial process, they require a personal guarantee, including your personal residence. Most commercial banks don't ask or definitely don't receive a secured interest in your personal home for that business-related corporate loan. They may ask for a personal guarantee, but it's usually not on your personal residence. SBA, they will always ask for a secured interest in your personal residence. So, I'm actually a fan of the SBA. It is the opportunity to put down 10%, receive 90% in financing. If you're trying to keep all the ownership for yourself, leverage to the maximum extent possible, the SBA is a great way to bring in the financing. But if you don't have the SBA, you can't get the financing, then there's kinda where our forte steps in with the capital raise of doing a securities offering. When it comes to raising capital from investors, I've beaten that dead horse till it's not kicking anymore, so I'm not gonna go too deep into it, other than saying if you're going to be bringing in money from multiple investors, I don't care if it's debt, I don't care if it's equity, I don't care if it's a mismatch of unique smart contracts or whatever you wanna call it. There's a lot of rules and restrictions behind that. So just make sure that you're working with an attorney, a CPA, and a team that has experience and knowledge of how to do a capital raise where you're doing it legally, protected, and making sure you're taking the right steps all along the way. But I know we've talked quite a bit about how to set up the LLC yourself. And to the maximum extent possible, I'm a huge fan of DIY, do it yourself, save some money, there's no problem with that. But there are times that getting an attorney is an absolute you gotta do it. And that's if you're managing investments, you're doing syndication, you're bringing in investors. Another situation are multi-owners, multi-members, or joint ventures. Now, I wanna dive into just each one of these categories a little bit more. When it comes to the investment side, yeah, you're using an LLC to limit your own liability as the sponsor, the issuer. You're also making it very clear terms of the investment, including how profits are allocated, how voting is allocated, how taxes are allocated, and what controls the management has without having to go to the other owners, AKA members, and seek a vote. Very similar situation if you have multiple members and there's a bunch of people that are involved with your LLC. Again, ambiguity is the source of all disputes. Not seeing eye to eye or not having the same understanding of there's a dollar of profit. Who gets it? There's management fees. What right does the manager have to receive salaries or fees? And what voting rights may there be of the passive owners versus what action rights and authorities and powers the manager has. So that's where having if you have a bunch of different owners within an LLC, having that operating agreement is unbelievably important, and having just a generic, simple, straightforward template puts you at a bigger risk. So on that landing page that I provided the link to, that includes a template of an operating agreement. And just to be incredibly clear, that template should only be used for you are the owner, you are the member, single owner, single management. That's it. If you have multiple owners, you're bringing in investors, or if you're doing this as a joint venture, always, always, always get an attorney. And where I'm bringing up the joint ventures, again, if you and I just went out, we created a partnership. Hey, we're gonna go open up that store. We don't need an LLC. Somebody slips, falls, breaks their hip. They sue the store. Now it doesn't matter if I owned 99% or 1%. I can owe 100% of the losses and liability that injury, that issue can create. So that's where I really wanna emphasize. If somebody says, "No, no, no, we're not partners, we're just doing this as a joint venture," please make sure that you are using and leveraging a LLC, an operating agreement, as directed and advised. So the next area that really wanted to just kinda take a couple of minutes to dive into a little bit more is asset protection and how asset protection with an LLC really works. And to start with, I consider it there's different directions, vertical or horizontal asset protection. Now, vertical asset protection, I think about it as if something happened to the business, can those creditors reach my personal assets? There's one type of asset protection. Second type of asset protection is I own a business and then I personally get sued, and I wanna make sure that they don't have reach to get the assets of the business. That is still the vertical asset protection. It just goes both ways. Problem at the business, problem with yourself, but you wanna make sure that you're protecting the assets that are personally held or in the LLC. Another is horizontal asset protection. And when I talk about that, it's all of your businesses, all of your real estate within one LLC, and that LLC gets sued, all of those assets may also. And so we're gonna talk a little bit about series LLCs, and I absolutely hate how, there's a lot of, animation with this one. So, with the series LLC, if you only have a single LLC, all of these assets are owned in that LLC, and there's a lawsuit, that creditor can reach all of your assets. Not a good situation. So that's where we'll use, and traditionally we've used a bunch of separate LLCs. When I started practicing back in the day, almost 20 years ago in Nevada, we would have a parent holding company going along with 20 plus different LLCs, all owning different pieces of real estate. And the reason why we did it was exactly for this example. If there was ever a lawsuit, if there was ever a problem, it affect a singular LLC versus affecting all of the assets that the parent company would own. When it came to series LLC, which I love, it gives the exact same protections as having all of the different LLCs already organized. If a lawsuit for one series, you can think about it like a subsidiary, that asset is protected from all of the other series. We used to do that through having a whole bunch of different LLCs. Now, about 25 years ago, the concept of the series LLC started coming in vogue, and that allowed, instead of having 30 different LLCs, all with different assets, all with underneath a parent company, you could just organize one series LLC that provided all of those similar protections, asset to asset, making sure that all the assets are protected from one another. All with a properly set up series LLC, if there's a problem with one of the assets, they can't reach you personally, which is a huge part of the asset protection. So now with leveraging a series LLC, which, there's hasn't been the best level of understanding of what they are, only because they've been around for 25 years. LLCs have been around for 50 years, limited partnerships, 100 years, corporations, 400 years. So it is a little bit of a newer animal. It has not been challenged in the court system enough through time. However, it's been 25 years. They're being more and more accepted and subject to more and more challenges. So the Series LLC is protecting you personally from problems at the LLC level. The Series LLC also is protecting all the assets that are held in different series within the LLC. And then the greatest, and the biggest part of asset protection is a strategy to be able to remove ownership from yourself, not losing control, so you can still control and manage the series LLC. But if you remove ownership from yourself and put it into a trust, now the trust doesn't have any activities, does not put itself out there at risk. If anybody sues you as an individual to get at your assets, now all of a sudden, this series LLC, all of these properties themselves, they're no longer your assets. They're owned by the trust. So that's where leveraging LLCs to protect you from the assets of the LLC is important. A series LLC protecting the assets from one another if there's a lawsuit. That gets to be important. And then the ultimate level is attaching a irrevocable trust to your series LLC that you own and control. You still have check writing capabilities. That gets to be the ultimate asset protection. So if you have any questions about asset protection, please, I'm happy to answer any, to go down those rabbit holes of talking through the good, the bad, and the ugly of if you're trying to get yourself protected. So if you want, please feel free to email me, Nate@investmentlawyers.com. If you go to this QR code, you will be able to download all of the information that previously provided, as well as if you want to set up a call. Everything is available right there. So we have covered a lot of information. Haven't had the opportunity to check out how the chat's going, if there's anybody put out any questions. All right, we got some questions in here, so I'm just gonna run through it and answer some of them. Res ipsa loquitur. Charging order protection isn't available in every state. That is absolutely true. Just to explain how a charging order works. A charging order says, okay, well, if you get sued, your company gets sued, the only resources that the creditor can receive are from the profit distributions from the LLC. That is in and of itself a level of asset protection. You have an LLC, a bunch of your assets are in there. You personally get sued. The creditor gets a judgment against you. Well, they can't get to the assets of the LLC other than the distributions that are made from them to you, and that's called a charging order. It does protect you in a lot of the larger states, especially that focus on asset protection, all that we had covered with Wyoming, Nevada, and Delaware. They have the charging order protections, but not every state has it. The end run to making sure that you have the ultimate protection is to remove that ownership from you, AKA leveraging a trust to hold on to the ownership where you still have management control, and then you're outside of the charging order risk in any way, shape, or form. So thank you, Resipsa, for bringing it up, but you are absolutely correct. Irish is asking how the new transparency regulations affect the filings with Delaware or any other state. The transparency regulations are requiring filings with the federal government. They are still putting together all of the processes, requirements. This is how to file. So when that is effective, it will be a direct filing with the federal government. It will not require a filing at the state level. So in terms of setting up the LLCs, it doesn't really matter. Gene Massey, my good friend, in Wyoming, you are statutorily indemnified, and that is true in most of the states that I had covered. They're there for asset protection purposes. Does a registered agent have to be located in that state? Yes, that is absolutely 100% behind the requirements of a registered agent. They have to be located in that state that the entity is actually being set up. Are C corps subject to the same reporting of shareholders? Yep, you got it. The federal government is saying we don't like the fact that everybody's hidden, which that's how it's been forever. Now the government overreach is reaching in there to get a little bit more information. And that is the FinCEN registry that is on the horizon. They're still working on that process. We will have a overview once it all gets released. But for right now, we know that there's going to be a filing with the federal government that's going to disclose all of that information. Jason asking about the secrecy laws of Wyoming, and you are correct. It is not hard to find out who is running an LLC in Wyoming or Nevada. It is substantially more difficult in Delaware, but you can search for who the management is of any Wyoming LLC. The only way to get around that is you can have an LLC or a trust managing the LLC. That does help kind of obscure the ownership, it obscures the management controls that, does apply. However, at the end of the day, and something to really remember, there will be filings with the federal government. We don't know to what extent they're gonna be searchable. or if it's gonna be more like the IRS rules that, frankly, you're not supposed to have access to all that information. We don't really know, we'll see, but right now, it is just the state level laws and rules that are providing the information, or giving access to the information about an LLC to the public. In the states that we've talked about are some of the best that are out there. So I wanna thank everybody for taking your lunchtime, a little time throughout the day, just so we could get back to some of the basics of LLCs. If you need any help, you're working on some bigger transactions, please reach out to us at Crowdfunding Lawyers. But until next time, thank you so much and have a great